is Mark Pacella. Mark received his BA from the University of Pittsburgh and his JD from Antioch School of Law. He is a member of the Pennsylvania Office of the Attorney General, and he's been there since 1987, and he currently serves as the Chief Deputy Attorney General in charge of its Charitable Trusts and Organizations section, which performs the office's supervisory role over property committed to charitable purposes. Among the office's more notable cases are the Milton Hershey School Trust and the Barnes Foundation. Some of you might have heard of those. Mr. Pacella is past president of the National Association of State Charity Officials, and the moniker used for that is NASCO, which is an affiliate of the National Association of Attorneys General. He also serves on the advisory board of the Charities Regulation and Oversight Project of the National State Attorneys General Program at Columbia Law School. He's a member of the Pennsylvania Bar Association's Charitable Organization Committee and a speaker and faculty member at a number of nonprofit and charitable trust conferences, and he is a veteran of the United States Navy.
Can everybody hear? Yeah, we can hear. I have to start my session off with the usual disclaimer that goes something like, what I'm about to tell you now is my own opinion. I don't represent, or I'm not speaking for Pennsylvania's newly elected Attorney General Kathleen Kane or any other state Attorney General's office. So fundamentally what that means is you're all free to completely ignore what I'm about to say. I'm also glad to see that Professor Wolf hasn't come in. I hope he does not return during my session, because that term creep issue he has could be damaging to him. If I don't leave you with anything else today, I hope, and you've heard some of the other panelists make reference to AGs. AGs really do have the primary regulatory responsibilities to protect the interests that every one of us in this room has over property that gets committed to charitable purposes. Everything from scholarship monies to Meals on Wheels programs to 1,000-acre ranches that are committed to conservation easements. You name it, it falls to the AG's offices primarily to oversee and ensure that whatever interests we have are being adequately represented, that those assets are being duly administered. And just briefly to summarize and sort of close the loop on some of the other comments that you've heard, the case law makes pretty much, I think, a good case for this, and it points out that if it wasn't for someone in government to do this, to perform this role, none of us individually typically will have a sufficient stake in ensuring that these charities are doing their job. That would just be a very severely flawed public policy. It really falls to government to ensure that our interests are protected. And historically, as you've heard from Marion Fremont-Smith's presentation, that has really been delegated to state AGs. There is some confusion about how AGs and the IRS overlap. We do have some important synergies. There are some, we both are concerned very much about private inurement, excess compensation, prohibited investments, conflicted transactions. All of that stuff is as sensitive for us as it is for the IRS. The thing to keep in mind is that the IRS enforces, and our state revenue offices enforce, our tax laws. It's about enforcing the taxes that are due, and they're responsible for the collection of those taxes. State AGs, on the other hand, really have a much broader perspective, and our role, as I described, is to protect the administration of those charitable missions. We're all about charitable assets. We're concerned about charitable compliance and that people actually deliver on the promise. With that, to the extent that the IRS can revoke an exemption or impose penalties for violation of a tax law, that typically reduces down to money and a consequence that costs the charity some revenue and some assets. The relief that's available to state AGs is much broader. We can surcharge individuals who mismanage, waste, or lose charitable assets. We can remove them when the situation is appropriate. And the injunctive relief is really going to be virtually limitless based on the facts at hand, and can run all the way up to the revocation of the Articles of Incorporation or whatever. The equivalent of a capital case where you would basically put the person to death. There would be no charity there. The organization would go away. The assets would be distributed to some appropriate successor. We do this stuff by enforcing whatever laws we have that are applicable. And because of the diversity in this area, the concepts that we're talking about and that I'll mention today are really consistent with these general common law principles. And you've heard a lot about, the charitable trust, cypre, deviation, and all that sort of stuff. Those are the sorts of things that we would fall back on. And in the context of conservation easements, which I have to say, my opportunity to participate in this program today, and a symposium that was last year were just really valuable because I've taken away from these experiences far more than I think I contribute. I really didn't fully appreciate all the nuances of these conservation easements and just how interesting they can get. I don't know, I don't want to insult anybody, but for those of us in AG's offices, it might be fair to say that we sort of dumb down things right to their essence. You know, if there's a restricted gift, if you've given money to charity, and this goes back to Professor Wolf's comment, you know, personally, I don't like getting caught up in a lot of specific terms and stuff. That only causes the right thing to be that much more difficult to have happen. If we think that you've got money and you're administering a gift that's been given to benefit the public, that's probably going to be enough for us. We will most likely take action when we think that those interests are being mismanaged or abused. And this whole universe of conservation easements, I think, is pretty interesting because there's this wide continuum, a spectrum, if you will, of where those interests are. The greater the public interest, the more likely you're going to see interest involvement. If a developer, in the course of developing a tract of land, sets restrictive covenants or puts a conservation easement on some common land, that when it's all said and done is really for the primary benefit of the people who've purchased those lots, purchased those homes. Legally, there's going to be a conservation easement there, and unquestionably there may be some issues regarding the way those assets are being managed. But given the resources the state AGs have, if that's the extent of the public interest, that is not going to be weighted as heavily as some of the other examples we saw earlier today where there are significant tracts of land that are given that are clearly going to impact the public at large rather than just a very small set of landowners who may be adjacent to that property. Again, it will depend on just what's happening in that given case. I'm not suggesting that that case will never get evaluated or pursued by an AG. I'm simply saying that those kinds of decisions are being made in AG's offices every day in terms of just how much of a public interest is there in this case, and do we need to participate. If there is the participation of another entity, if a nonprofit, if a conservation organization is already stepped into the breach, under that case very often because we don't typically always have the resources to pursue that. But as you heard earlier, and I think in some of Professor McLaughlin's presentation, even small states, like Wyoming, that has a relatively small state population and very little resources, was able to step in and take care of whatever was in the mix. Maine, as we've heard, although Maine is also a small state, it has a strong history, and as we'll hear about New Hampshire, same situation. So it's an interesting set of circumstances. It's true states don't always have the same amount of resources, and there's a lot of variety, I guess, and different levels when you go from state to state. But I think on average, and certainly whenever there's an important case, the more substantial that public interest is when it gets presented, the more likelihood that you'll see the AG appear and participate. The thing that I want to make clear about this is that the notion that you've got very small offices and there is, as Marion had pointed out, there is this disparity. NASCO that you heard about discussed earlier was something that was formed to try to help state offices and state AGs address that disparity. We come together for a conference each year. We communicate through a listserv, telephones, just like everyone else, but we have been, I think, a relatively effective tool to help share information, share expertise when we have it to share, get expertise when we don't have it and need it. It's been a pretty good relationship, I think, for most all of the states that participate, and most of the states do. I think we've had in our last conference and at the Columbia conference, I think there were 40 jurisdictions there. So that's consistent with what you heard Marion talk about in terms of states are becoming more and more active in terms of at least the number of states that we see in some of these conferences and all, which is a good thing. Most of the work that we do, and this ties back, I guess, to some of the confusion about, well, where are the AGs? Most of the work we do outside the context of litigation. And you've already heard some of the explanations for what it is. First, unless we're dealing with an outright corrupt organization, if this case and it looks like it's just packed full of a bunch of liars, cheaters, and thieves, we don't have any problem with taking those cases to court. it's the legitimate bona fide charitable organization that has been in existence for a couple of decades. It's taken 10, 20, 30 years for them to build this reputation, this goodwill, the footprint in the community, if you will, and their program. And because of a few missteps, if you will, or some dalliances on the parts of some individuals, we're very sensitive as to how we handle that case. I can tell you firsthand that it is probably next to impossible for an organization to recover if there are public allegations that its board engaged in self-dealing or has breached fiduciary duties, lost assets, committed criminal acts, that sort of stuff. I'm not saying every charity goes away, but no charity remains the same, and no charity walks away from that feeling that, yeah, we really survived that bullet. So we're very circumspect in how we pursue those cases. The last thing we want to do is go in, file an action, win the case, and watch the charity die on the vine and eventually lose all of its public support and have to be dissolved. There's really little cause to celebrate those kind of outcomes. Litigation costs money. When we're suing, if we do sue with an organization, and even when we don't sue, I think as we've already heard, the cost of that process, however it is public on both sides of the transaction. We're burning up public resources through the AG's office. We're burning up public resources on the charity side, and of course our court system is all publicly funded. So if we do go, when we do go, those cases you can probably expect you are hearing about them because every other effort to try to avoid that has failed, and AGs are sort of stuck with no other recourse but to go to court. And then, of course, you may not believe this, but AGs always don't get what they want when they go to court. So litigation is difficult to control. It can confound you at times. You can be very sure that, what judge isn't going to agree with this? And they don't always agree. So for the parties that are ever finding themselves in a situation where they're having to try to resolve a problem or a dispute, the opportunity to control your own destinies through a resolution that you have some input in, and not having to take that mandatory decision from a judge, which may be substantially less than what you're hoping to achieve, can be a pretty powerful driver. We did talk a little bit about the offices. In some offices, the disparity between the resources sometimes can be pretty dramatic. They may have no one who's assigned to do just charities work. Pennsylvania has the benefit of having, we do have people that do nothing but charities every day. Some of the other larger states do the same thing. But I think, as I said, I think we've done a pretty good job of coordinating efforts and trying to help each other actually deal with the problems that come up. Our relationship with the IRS is pretty positive. We've had very good rapport in impacting the 990s, inputting on stuff that we think could improve the 990 forms and all. We're not quite as effective in information sharing. We're hoping to be able to increase that, improve that. The Pension Protection Act in 2006 did expand the information that the IRS can share with state AGs. But left in place the restrictions on the use of that information and the penalties for an unauthorized disclosure. And that really is sort of confounding us. None of us want to go to jail for violating those rules.